Welcome back to the channel, everybody. We are diving into breaking news today. Blake Lively's pulling an Amber Heard and sending a subpoena to Bryan Freedman and Justin Baldoni's lawyers. What? I'm not going to lie. I was shocked when I saw this, but I don't know why I'm shocked anymore. I genuinely don't know why I'm shocked anymore with this case. But we're going to go over the documents. I have the documents here. I don't know if anyone else is having troubles with Court Listener today, or I've just been kicked out of it. I don't know. Maybe Blake got me banned from it, but I can't load it. But thankfully, I had this document saved. We're going to go through it top to bottom. I'll give you guys my theory. For those that are new to the channel, I'm not a lawyer. I don't even play one on TV. I'm in branding and marketing. So I've had over 15 years experience in branding and marketing. And my particular interest and focus is SEO, which is search engine optimization and reputation management. And that's what we talk about here. We don't go through every court document, but the ones that relate to how it can be twisted into PR, which for Blake, it seems like everything can be, we talk about it here. But it's a fun, unique lens on the Justin Baldoni, Blake Lively lawsuits. Hello, guys. The chaos never ends. Is that not the truth? That is so true. It never ends. How are you guys? And Mel's saging for us. I love this. We're going to need it. Everyone say hi in the chat. If you're new to the channel, the chat's so sweet. Everyone's amazing here. I was up sick all night, so I might not be as bubbly and interactive as I usually am. I am very tired and feel very, very, very ill. But we're here. I couldn't miss this. Come on. How do you miss this? So we're going to read it. And I want to let you guys know before we dive in, for those that have been around for a while, you know that we run a farm animal sanctuary at my farm, but we also run a feral cat colony. And unfortunately, the last 6 months, so if you follow me on Instagram, the little cats that follow me around, I show you behind the scenes on the farm. That's the feral cat colony. They become tamed after a while. Like here, so we feed them, we take care of them, we treat them if they have medical issues. But the trap, neuter, release program that we use has stopped being active over the last 6 months. They closed down. We were able to find a farm or a vet that does farm cats, that does barn cats, feral cat colonies, but it's a lot more expensive. It's about $100 roughly per cat versus before it was like $40 per cat. So we have, I think, 4 females, 2 males right now we need to bring in. And if you guys are interested in supporting our feral cat colony, I'm going to drop the PayPal link that goes directly to the farm. So every dollar there goes directly back into the farm for our farm animal sanctuary, for feed and medical bills. So that will all go towards helping out the feral cats because we already have, believe it or not, 2 sets of kittens. So that really sucks, to be quite honest. And I hate adding to the pet overpopulation issue. So that's there if you guys are wanting to support the feral cats getting spayed and neutered. Someone said it's glitching. Does it seem okay for everyone else? Let me know. Pace yourself. Thank you. You know me, I get so worked up over all of this, and we'll see. I'm probably going to need a nap after this, to be honest, because no doubt I'll still get worked up and then just drain myself. Okay, guys, let's grab our popcorn, grab your florals, grab whatever you need to grab, your tea, your coffee, your wine. Let's dive into it. So this dropped yesterday. It's a joint stipulation pursuant to local rules 37 and 45, remotion to quash subpoena to produce documents served on Linear, Freeman, Tattleman, and Cooley LLP. And I think in a lot of the document, what we're going to see is it's referred to Linear throughout, which is Justin Baldoni's law firm. And it's Blake Lively that served them. Right off the bat, I'm going to give you my theory before we get too far into this. I think she learned a lot from the Amber Heard case. Number one, what I think she learned, let me know in the chat. Did you guys watch Johnny Depp versus Amber Heard case? Oh my goodness. I got nothing done, first of all, during that trial. I was like, I'm not launching anything. I'm not taking on new clients. I was so enthralled. But Amber made one mistake. And what she did was she was able to get charged for defamation because she made the statements. I think it was like I don't know X that well, but it was like a quote or something on an article she wrote without litigation privilege. Blake has litigation privilege. So I think she learned from Amber Heard in that respect. But I also think she's kind of taking another page from Amber Heard's playbook. Because if you watched it, all right, you guys, all of it. Yeah. I love it. I watched Step for Be Heard. Perfect. You guys are my people. If you watched the trial or you followed that trial, what did she do? What happened to Adam Waldman? Adam Waldman was Johnny Depp's like right-hand man lawyer, right? Kind of like Bryan Freedman is to Justin Baldoni. He had made statements to the press, which Amber Heard said were defamatory. And that she did, I believe, if I remember correctly, and I know you guys will correct me in the chat, but I do believe she actually won on that one. But either way, he was removed. So Adam Waldman was removed from the case. He was not allowed to be Johnny Depp's lawyer. And I think she's pulling a page from that. I think she wants Bryan Freedman off the case. And this is how she's going to do it. But I also think there's another piece to this with Blake serving them this subpoena. When I was looking over it briefly, I haven't read the whole document, but looking over it briefly, to me, the timeline looks like this all started, the wheels started around the time Bryan said that someone came to him from Taylor's camp and claimed that Blake Lively was extorting Taylor. I think this is also her way to be like, I am getting these effing documents. I'm figuring out what Blake or what Taylor said about me, and I'm going to get these documents no matter how I have to get them. I honestly think that's what it is. I don't think Bryan Freedman has documents. My theory on this is that Venable and Taylor told him what to look for on Blake's side and that he'll go back to them if he can't get it from Blake. I don't think he's lying. I think he got everything he needed without actually getting documents. But anyway, let's dive in. We'll all share theories as we go. If you don't like commentary, this just won't be the channel for you. So there's that, because we like to hang out on lives. We like to chat. I like to say hi to everyone because it's a community here. Hello, hello, guys. It's so nice to see you. And not everyone likes that, but that's okay. Moving party liner Freeman, Tattleman, and Cooley LLP introductory statement. Let's do this, guys. Respondent Blake Lively has served a breathtakingly overbroad subpoena directed to the law firm representing the Wayfarer parties in a highly publicized set of litigations arising from the Lively's allegations of SH on the set of the film It Ends With Us. So this is Bryan Freedman writing this. The litigation pending in the Southern District of New York has caused a media and internet frenzy fueled mainly by the celebrity status of Lively and her husband, Ryan Reynolds. Although the media coverage was initially favorable to Lively, as more facts and evidence emerged, the tables turned and Lively has become the target of a storm of negative media coverage. And I agree, it was originally people were siding with her. Rather than accept responsibility for her own precipitous actions, which sparked the media frenzy, Lively would like to shift blame to the Wayfarer parties and their counsel. The overheated media coverage of the Lively-Baldoni dispute is merely a sideshow. Nevertheless, Lively has now served an exceedingly broad subpoena, not on the Wayfarer parties, but their counsel, targeting LFTC's contacts and communications with traditional media outlets and digital providers. So that'll be your content creators, which she's still going after. If we have time, depending on how long we're going and if I can hold up that long, we'll go over that as well. If I can get Court Listener to work for me as well, because it's not letting me in. Sources of information allegedly conveyed to the media and even LFTC's financial and telephone records. The individual requests are on their face extremely overbroad, sweeping and privileged communications and work product and reams of information irrelevant or only tangibly relevant to the parties' claims and defenses, which you gotta laugh with Blake Lively, because she would have a connipshit if they did this to her. But she can do whatever she wants. Why can't you ask Taylor yourself, Blake? Yeah. Why don't you just call Tay-Tay up, Blake? Oh, wait. You got to serve everyone and their chihuahua with a subpoena because your bestie isn't talking to you. It's just wild. All right. Justin, what does it say here? The subpoena is part of the multi-pronged attack on counsel, as this is a footnote. Is that what they call it? I don't know. Not a lawyer. As part of an overarching strategy to intimidate counsel. Lively and Reynolds have also filed improper motions for Rule 11 sanctions based solely on alleging pleading deficits, which are properly challenged by a Rule 12B6 motion to dismiss. So they're coming out hot saying it's a strategy to intimidate counsel. It'll be interesting because, again, my experience, my background is in branding, marketing, essentially PR. That's what reputation management and SEO is, although I don't like traditional PR, so I don't do it. But I'm going to be interested to see and to watch how this works its way out into the media. Because y'all know the media is going to pick this up. Like, this just dropped last night. This is going to go wild. And both sides are going to want to get their story out in regards to this. So it'll be really interesting to see. The subpoena also includes 14 pages of prefatory statements or definitions and instructions, 38 complex definitions, including number 31, which has 9 subparts, exponentially expand the scope of 8 individual requests. See example A. The definitions are not merely vague, but in some cases inscrutable, requiring LFTC to guess as to what is being sought. You know what's hilarious about that is one in the response. So for those that watched the live yesterday, Blake had until 5 p.m. yesterday to follow up in regards to this motion to compel the content creators. And this is what they're complaining about Bryan Freedman doing. Oh, you're making us guess. It's not clear enough. You're making us guess on who you mean when you know who the content creators are. So again, the interesting thing for me is like everything that Blake and Ryan accuse Justin and his team of doing, the reason why they accuse it is because they project. The reason why they accuse it is because it's what they do. And this is an example of what they do. It's vague. Some definitions, such as those for Miss Swift, I haven't read further than this paragraph, but I am dying that Blake continually, she just won't let that bone go. She will not let Taylor Swift go. And then blames Justin and blames Bryan Freedman for it. When it's her and her team that won't shut up about Taylor Swift. Like, I understand this is Bryan Freedman writing this, but he's responding to the subpoena where they included Miss Swift in it. So for those with Miss Swift, Tag and Wallace are super frivolous as the terms do not appear on any of the requests. The sheer breadth of the definitions and instructions alone speak volumes about Lively's real intent, and the most cursory view of the subpoena raises the specter that the subpoena's primary purpose is not to obtain legitimate discovery, but to intimidate and harass the Wayfarer parties and their counsel and multiply the proceedings and their costs. I mean, seems about right. Unless Blake's pooping her pants over having to be deposed by Bryan Freedman, she's trying to get him out ASAP. Courts disfavor efforts to obtain discovery from opposing counsel and apply 2 tests to determine whether to permit such discovery. The 8th Circuit's Shelton test, isn't that being used in Karen Reed right now? I feel like that name came up, which is routinely used in this circuit, requires a party seeking discovery from opposing counsel to show that 1, no other means exist to obtain the information, 2, the information sought is relevant and not privileged, and 3, the information is crucial to the preparation of the case. Shelton versus Ammer Motors Corporation. Failure to establish any prong of the Shelton test is grounds to quash a subpoena to opposing counsel. Other courts apply the Second Circuit's more flexible Freedman test, which considers all relevant facts and circumstances, such as the need to depose the lawyer's role in connection with the matter on which discovery is sought, and in relation to the pending litigation, the risk of encountering privileged and work product issues, and the extent of discovery already conducted. Under either Shelton or Freedman, the subpoena should be quashed or drastically modified as it imposes an excessive and undue burden on the litigation, invades the attorney-client and work privileges, and opens the door to the discovery of LFTC's litigation strategy. Well, yeah, that's probably also what Blake's going for. That's probably also what she's going for. This is exactly what it is. It's a narcissistic temper tantrum in court. 100%. It's a good way to put it. I can't wait for the response. This is just wild. In fact, Lively's subpoena flies in the face of well-established authority and policy frowning on efforts to obtain discovery from opposing counsel and deter such litigation tactics. Miss Lively's introductory statement. I actually like this. So here's the thing. I find a lot of people have a negative connotation of PR, especially if I talk about PR in their faves. People will thumbs down my videos so fast if I say like, oh, Justin's used this for PR. And they're like, he doesn't need PR. Thumbs down on your video. Or if I talk about Taylor Swift or anyone, people have an aneurysm and they're like, no, they're not doing that. PR is not bad. This document is also fantastic to get their side of the story out and why this is bad, why Blake is out of line here. So PR itself isn't negative. So when I say that this has the potential to be really good PR for Bryan and Justin as well, it's not negative. It's not shady. PR isn't inherently shady. On December 31st, 2024, Miss Lively initiated litigation, the Lively action in the Southern District of New York, in connection with SH, she and the others experienced while filming the movie It Ends With Us. I still want to know who the others are. Because she keeps saying that she's standing up for others on the film, but in subsequent retaliation designed, in the Wayfarer Party's own words, to bury her for speaking out. See Declaration of K. Bender Declaration, and Exhibit C, Lively complaint. Miss Lively alleges that she and other employees, cast and crew of the film, were the subject of unwelcome and inappropriate behavior by Mr. Baldoni and Mr. Heath during production of the film, and that she was retaliated against through a social manipulation campaign by the Wayfarer parties for lodging her grievances regarding the conduct of Mr. Baldoni and Mr. Heath on set. This social manipulation campaign was intended to be, in the Wayfarer party's own words, untraceable. But apparently she's able to trace it. Since the law, and I just want to say something and interject here. If they hired bot farms, that's not untraceable. So I don't know why they keep calling it untraceable, because if they hired bot farms, you would be able to trace the money to the bot farms, to the companies that were doing that. So I don't know. Since the Lively action began, Miss Lively has issued substantial discovery to uncover the tracks of this untraceable campaign by identifying and obtaining evidence from the Wayfarer Party's network of agents who have participated or are currently participating in the campaign. Miss Lively has alleged that Linear, Freedman, Tattleman, and Cooley LLP Linear is part of this network. So let's go back up here and see what was said. By moving to quash, LFTC does not admit the existence of documents responsive to any request that are in the firm's possession, custody, or control. Miss Lively brought her claims against Wayfarer Studios LLC, a production company that co-financed and produced the film and was the employer of all cast and crew on set, including Miss Lively, as well as Justin Baldoni, the co-founder and co-chairman of Wayfarer, who starred in, directed, and served as a producer of the film. Jamie Heath, the CEO and former president of Wayfarer, and several other Wayfarer executives, affiliated entities, and crisis and public relations professionals. For purposes of Miss Lively's portion of the joint stipulation, the term Wayfarer Parties also includes Jed Wallace Street Relations, Inc., an agency group PR LLC. When did Jamie step down? Jamie Heath, the CEO and former president of Wayfarer. Specifically, Miss Lively alleges that the campaign was carried out in connection with the engagement of Jed Wallace, an individual who specializes in executing confidential and untraceable campaigns across various social media platforms, and his company, Street Relations. Blake, I want to know if your friend Nick Shapiro that used to work for the CIA, oh no, and I'm going to say the words and it's going to tank my reach, whatever. When I did my exposés on Nick Shapiro, my reach tanked on YouTube. I hit such a low in my channel, nothing was being seen. But anyway, we'll say it anyway. Nick Shapiro, who she hired, used to be CIA and also was the leader of the black box team with Airbnb. I have videos on that. So I want to know, does Nick Shapiro know anything about untraceable campaigns, about PR, about preventing things from getting in the media, about using, I don't know, media contacts to manipulate headlines? The answer is yes, Blake. Yes, he does, because it's easily accessible, the history that Nick Shapiro has. So again, pot calling the kettle black. Miss Lively alleges that Mr. Wallace and Mr. Freedman of Linear have a very close relationship and began work with the Wayfarer parties in mid-August 2024 during the initial time period of the alleged smear campaign and months prior to when Miss Lively brought suit against them. So this looks like it's from Melissa Nathan to Jennifer Abel. Can I start a signal thread with you, me, and Jed, just in case you need him to contact you to connect you to Bryan? Oh my gosh, my eyes cannot. I need glasses because they're very close. Okay. So they were going to start a signal thread with Melissa, Jen, Jed, so that they had access to Bryan. So I'm guessing Blake Lively put that in the subpoena and why she needs to subpoena Bryan Freedman. Miss Lively further makes extensive allegations about Lanier's role as an agent in the Wayfarer Party's ongoing retaliation campaign and defamatory conduct that she did cause the media frenzy. Freudian slip that have caused the media frenzy and overheated media coverage that Lanier claims is self-inflicted. In particular, Miss Lively alleges that since receiving such notice of the CRD complaint on information belief, Wayfarer, Mr. Baldoni, Mr. Heath, and their associates ramped up the retaliation campaign against Miss Lively, continuing their efforts to bury and destroy her to this date, deploying the same flood the zone tactics. I think it's hilarious that she claimed they were using flood the zone tactics. Not that I think they're watching my channel or anything, but she accused Justin's team of using flood the zone tactics. I've never seen those words used in a lawsuit like this before. It's well, I guess a PR lawsuit, so it makes a little bit more sense. But a week before, I had accused her and Ryan of doing flood the zone, and it was like trending on X. It was trending on YouTube about this flood the zone that Blake and Ryan were doing, and then all of a sudden she's accusing Justin Baldoni of flood the zone. Like, it was literally the exact words I had used. I thought it was hilarious. Anyway, so she accused them of using flood the zone tactics to overwhelm the process and confuse people. Defendants and their agents acting at their direction have pursued a highly public media blitz and litigation strategy to attempt to discredit Miss Lively and Mr. Reynolds. I think they discredit themselves, but what do I know? A relentless media influence and digital manipulation strategy remains at the heart of defendants' campaign. As before, defendants have directly engaged with media platforms to overwhelm and confuse the public's understanding of Miss Lively's allegations and to drive negative sentiment towards Miss Lively and anyone who supports her or speaks out against Mr. Baldoni. I believe it was organic. She started getting backlash when she was originally cast in the role. I remember the internet blowing up because people were like, she's way too old. What about those frumpy clothes? So she had backlash from the beginning, and then she markets, it ends with us with that bizarre marketing that her and Ryan came up with through Maximum Effort, which is their marketing company. She has no one to blame but herself. And at the end of the day, everyone uses PR. So I'm not going to be like, oh, Pikachu face, shocked Pikachu, if it comes out that Justin was using PR tactics. I'm not be like, oh my gosh, Justin, I don't trust him anymore. No, it's part of the game. For any company, any brand, anyone. I still think she had negative press going back to the beginning of the filming when those photos leaked of her in their frumpy ass outfit with her frizzy hair. I'm not want to speak about frizzy hair, guys. It is humid here, but I don't own a hair care company. And she got backlash then, and it just continued. But she needs someone to blame. So it continues here. This is quoting, much of this phase of the campaign has taken place in the form of statements by defendant's lawyer, Mr. Freedman. So this is what Blake Lively is doing. This is why I think she is using Amber Heard's past with sending a subpoena to Adam Waldman. He got removed from the case, and it was all because of statements that Waldman had made. I genuinely think she's like taking a page from Amber Heard's playbook. But someone needs to call Blake and tell her what happened to Amber Heard. Because Amber Heard's never come back from it. So they're saying this campaign took place in the form of statements from Mr. Freeman, who regularly issues inflammatory content to media outlets, appearing on any show that will have him. That is such bullshit, Blake, and you know it. Including those hosted by his own clients. I don't see the problem with him going on Megyn Kelly. Just say her name, Blake. And saying anything, whether true or false, that will harm Miss Lively's credibility and intimidate others from speaking up on her behalf. Okay. Those statements, which have been circulated and viewed millions of times, constitute defamation as well as continued retaliation against Miss Lively for engaging in the protected activity of speaking up and bringing legal claims against Mr. Baldoni. I don't think Bryan Freedman has said anything horrible. Megyn Kelly has also been very honest that she is a client of Bryan Freedman's. He went on TMZ and Megyn Kelly. Her lawyer went on CNN, which I would say arguably is more going on anywhere that people will have you. If you're willing to go on CNN, you're literally just going anywhere people will have you, Blake. That's gross. CNN is gross. You're going to have fleas, and Gottlieb's going to have fleas from going on CNN. But you want to say that Freeman will go anywhere that people will have him? Okie dokie. She is a bizarre woman. As the above shows, Miss Lively alleges specific involvement by Lanier as a precipitant witness to an agent for this untraceable, I love that they always use it in quotes, and defamatory campaign. The subpoena is the only means by which Miss Lively can obtain information from a third-party co-conspirator who features heavily in Miss Lively's complaint for directly participating in and witnessing this untraceable media campaign well before litigation was filed and continuing through the present. Discovery, even as attorneys, is warranted in these circumstances. So says Blake. I'm just shaking I'm at a loss of words. As described herein, the court should transfer the instant motion to quash to the Southern District of New York. Okay, so as described herein, the court should transfer the instant motion to quash to the Southern District of New York. Federal R Civil P45. I'm not American. I don't know what all these stands for. Alternatively, the court should deny the motion because the subpoena seeks information that is crucial to Miss Lively's claims and can be obtained only from Lanier. All right. Transfer the motion pursuant to Federal Rule of Civil Procedure 45F, Miss Lively's contentions. This court should transfer the motion to the issuing court in the Southern District of New York. Exceptional circumstances warrant transferring the motion to the Southern District of New York. Under the advisory committee notes, transfer may be warranted in order to avoid disrupting the issuing court's management of the underlying litigation. Courts have also considered a number of factors relating to the underlying litigation, including the complexity, procedural posture, duration of pendency, and the nature of the issues pending before or already resolved by the issuing court in the underlying litigation. The prototypical circumstances to transfer are present here. Judge Lyman in the Southern District of New York has been presiding over the underlying litigation since it began, is familiar with the full scope of issues involved, has recently resolved the party's motion to dismiss, and is poised to address pending requests for relief as multiple third-party subpoenas. See example, lively action. Thus, efficient management of the underlying litigation and judicial economy strongly counsel in favor of transfer. See Helping Hand Caregivers, LTD versus Darren Corp. Transferring subpoenas related motion because the motion would be better decided by the court with control over the disposition of the underlying case, and the transferee court was familiar with some of the topics listed in the subpoenas, merit a finding of exceptional circumstances. Judge Lyman's familiarity with the issues underlying the subpoena is particularly critical here to allow for swift resolution of this motion in accordance with the case's expedited timeline, with contemplates substantial completion of the document production by July 1st, close of fact discovery on April 14th, and a trial date of March 9th, 2026. This is wild. To be clear, Lanier has no reasonable basis to claim that transfer would be burdensome, given that it is litigating the underlying case in the issuing court on a daily basis. For starters, Lanier maintains an office in New York. Moreover, numerous Lanier attorneys have successfully moved for pro hoc vice admission to the Southern District of New York litigation and are regularly participating in filings, conferences, and other activities in that court. Indeed, Mr. Freeman himself has previously argued that efficiencies favor consolidating issues in New York that the Wayfarer parties had initially raised in California. She has a quote here. After seeing ... your case management order, and just for the efficiency of this case, it kind of made no sense to be doing this on different coasts and with different courts. It seemed that so many of the issues are going to be so similar that to have it all in one proceeding in front of your honor would make the most sense. Documents requested pursuant to subpoena. Oh my gosh, this is 86 pages. Jeez. I agree. Judge needs to tell Blake to stop abusing the courts. She's driving me nuts. Does she not know I'm sick today? I need a day off. JKing. Wouldn't be I'd rather be nowhere else but with you guys. So on brand, yeah. Don't say Swift. Taylor's gonna be like, take my name out of your mouth. Stop saying my name. Ugh. Request for production number 1. I'm just shocked. I'm more shocked that I'm coming across because I genuinely feel like I got run over by a bus, but this is just wild. Blake literally, in her own words, has said she doesn't know what no means. And she continually proves it every single day. Request for production number 1. Agreements effective at any point from July 1st, 2024 through present, whether executed prior, on, or subsequent to either date, including contracts, retainer agreements, and engagement letters between or involving you. Hello, you, including on behalf of any Wayfarer defendant, any content creator. Oh my God, they will not drop the content creator thing. Blake, let it go. Oh. Concerning the consolidated action, Miss Lively, Mr. Reynolds, any Wayfarer defendant, the digital campaign, the film, or with any content creator who has spoken publicly regarding the same. LFTC's contentions. Request number 1 seeks past and present agreements. So LFTC is, just to loop it back around, Justin's law firm, Bryan Freedman. Request number 1 seeks past and present agreements between the broadly defined LFTC and the content creators. LFTC is counsel for the Wayfarer parties and has been since the inception of this dispute, when Lively first hurled her public accusations against Justin Baldoni. You know, here's the funny thing for me. Blake wanted to go public with this. She didn't have to go to the New York Times. She didn't have to have that article come out. She didn't have to, you know, you look back at the marketing of It Ends With Us, and she was begging someone to ask her what was going on. Begging. Even in the fact that she was having people unfollow him on Instagram. She's not dumb. She knows that was going to cause people to start asking what's going on. I bet Blake has nothing against ex-patriarch. Is ex-patriarch Ryan? I am kind of wondering if that is a sock puppet account for Ryan. Wouldn't be surprised. Ryan has sock puppet accounts, and he even did it. I have a video on it where he was astroturfing and had sock puppet accounts in Ontario, in Kingston, Ontario. I have a video on that. Courts disfavor discovery directed to opposing counsel over concerns of the burden such discovery places on the adversarial process and the potential of opening a backdoor to obtaining privileged information about an opposing counsel's litigation strategy. She definitely wants access to that. I don't even think that's a secret at this point. She wants to know everything. She wants authorship of this trial. And she is trying everything to have authorship of this trial. She's not going to have authorship over this story after. She's not even going to write a book about this. You bet Bryan Freedman and Justin Baldoni aren't going to let her write a book about it. So Blake, you're going to have to keep trying for that authorship piece. And Shelton versus American Motors Corp., the 8th Circuit articulated a test for discovery from opposing counsel, which requires a showing that 1, no other means exist to obtain the information. 2, information sought is relevant and not privileged. And 3, the information is crucial to the preparation of the case. Failure to establish any prong of Shelton is grounds to quash a subpoena to opposing counsel. The heightened standard for Shelton applies to document subpoenas. The 2nd Circuit formulated a more flexible test in the subpoena issued to Dennis Freedman and Freedman. The Freedman test considers all of the relevant facts and circumstances, such as the need to depose a lawyer, the lawyer's role in connecting with the matter on which discovery is sought, and in relation to the pending litigation, the risk of encountering privileged and work product issues. I mean, Blake has gone on over and over again about all these like secret work issues that people are going to get, like, I don't know, her formula for Blake Brown shampoo. I don't think anyone wants it, but all she's gone on about is that. But she doesn't care. Again, it's like what's good for Blake isn't good for anyone else. Blake can do what she wants. The risk of encountering privilege and work product issues in the extended discovery already conducted. The 9th Circuit has cited Shelton as the proposition that discovery from opposing counsel is disfavored and has applied the Shelton standard to non-deposition discovery involving opposing counsel. However, the 9th Circuit has not adopted either standard, with some courts favoring the 2nd Court's approach in Freeman. The Central District of California typically analyzes issues relating to discovery from opposing litigation counsel under the Shelton test, while also sometimes considering the Freedman test, Eric Pearson versus the Cincinnati Insurance, maybe INS. However, practically speaking, the two approaches are only slightly different. Under either Shelton or Freedman, request number 1 should be quashed as it imposes an excessive and undue burden on litigation counsel. First, the request is extremely overbroad and requires the application of sweeping and ambiguous definitions. Discovery requests should be properly particularized, and the LFTC should not be required to guess at what is being sought of from whom, i.e., LFTC officers, directors, employees, partners, members, corporate parents, subsidiaries. Oh my gosh. Similarly, content creator is vaguely defined as any individual or entity who seeds, generates, creates, or influences social media content or provides related digital services. Again, and that's been their beef with Blake talking about content creators before. It's like, well, basically everyone. That is who we are including. Everyone you've ever spoken to, anyone that has an Instagram, anyone that has a Facebook page, anyone that has a YouTube channel, like everyone. A description which is, to say the least, open to interpretation. I agree. 100%. In fact, these sweeping definitions embrace, among other things, any person who posts on the internet. Exactly. Vendors such as digital service vendors hired to provide litigation support. It's so wild. Ashley, please rest and get better. We'll be here. Oh, you're so sweet, Terry. Thank you. You guys are the best. This is the best community. In fact, these sweeping definitions, among other things, any person, okay, we already read that. In fact, request number 1 seeks agreements between LFTC and content creators through the present. A request for documents from opposing counsel during the litigation potentially implicate multiple privileges, including the attorney-client privilege, attorney work product privilege, and litigation privilege. Blake doesn't care. Now, if they sent this on her, can you imagine the PR shitstorm that she would put out to the media? Oh my God. I cannot bear that independent content creators cannot be controlled with legacy media. I do agree with that. The smear campaign is stuck in her mind. Has she even remembered the SH at this point? I don't even know if she remembers it at this point. The definition of digital campaign is equally obtuse. I like that word, obtuse, and broad. I used that word on a Blake supporter the other day, obtuse, and they got very offended. Embracing efforts of the Wayfarer defendants and or affiliates, employees, associated, or subcontractors to communicate information regarding Blake Lively, Ryan Reynolds, and the Lively Reynolds companies, Miss Lively and Ryan Reynolds families, the Wayfarer defendants, the film, or the consolidated action on any social media, news outlet, or other internet platform, and or seed, influence, manipulate, boost, amplify, or engage with social media algorithms, narrative, or virality, as well as use of bots or inauthentic accounts, as described in the Lively complaint. It also assumes a digital campaign exists or existed. And that's what I don't understand is, where's the proof one existed? Blake's proof seems to be people are saying mean things about me. That's her proof. I do agree with this too, and a way to make people like her again. I do agree with that. She never cared about the SH. She just wanted to get revenge because she can't stand that people don't like her. Yeah. She has to assume it exists. But so far, because she's essentially saying, well, I can't prove it existed and I can't show that it existed because it's invisible. But I know it's not invisible because I know you have this email with a draft folder that you're letting people into, or like but then how do you know that? Second, agreements between, Blake, do you have a draft folder between you and people you pay so it's untraceable? Is that why you're projecting again? And again, not to say that his team has not used certain tactics. I just assume that everyone's going to. I just assume everyone's going to use certain tactics when they're in a crisis PR situation. I still believe that even if they had amplified, let's argue for argument's sake, just for argument's sake, that Justin's team was amplifying things. It's still organic. It was still people going and saying the things in the first place. It was still people pointing out shit about Blake in the first place. I still believe, because if you trace back the issues that started with Blake, they started when pictures leaked of her on the set and people were pissed that she was in the movie. You can find that still on the internet. That's where issues with her in the movie start. And then she came out with this asinine, offensive marketing campaign, treating It Ends With Us, a movie about DV, as if it was Barbie. And we've talked about it in the past on this channel. And I can't remember who pointed it out, but they said, they were going for that Barbenheimer. And there was even news articles coming out about it, right? But they didn't realize, and this isn't me realizing, there was someone in the chat here said what they didn't realize was It Ends With Us was the Oppenheimer, not the Barbie. So they got the movies wrong, they marketed it wrong, and then they blame everyone else. And they're accusing everyone else of being bots or paid off. But even if I wouldn't be surprised. So guys, I wouldn't brace yourself that it might come out that he's had maybe he's used PR to amplify. Okay. Everyone does. I don't understand. I still believe, and currently, unless something crazy gets said or something in just out of left field comes, I know for myself, I was originally on Blake's side. But when I started to look at things, and I wasn't really following, I didn't want to watch the movie, to be quite honest. It wasn't the genre I watch. I didn't watch the marketing, but when I started to look at things, I was like, well, that's weird. And then when I started to see how everything was coming together, yeah, you start to question things about how it was marketed. And then you look at all the proof that was coming out, and then you start to question her claims, because she backtracked on a lot of them when proof came out against her. All right, let's continue. The Common Interest Joint Defense Doctrine expands application of the attorney-client privilege and work product doctrine to communications with third parties in pursuit of a joint strategy in accordance with some form of agreement, whether written or unwritten. An agreement also may be implied from conduct or situation that the communications are intended to be confidential. This principle applies to public relations consultants who assist in the rendition of legal services. Communications among target, her lawyers, and public relations firms for the purposes of giving or receiving legal advice were protected by attorney-client privilege. Confidential communications between public relations firms and corporations counsel that were made for the purpose of rendering legal advice were protected by attorney-client privilege. Communication with a public relations firm were protected where firm functioned as in-house public relations firm. That's what Taylor does with Tree. Tree's in-house. Works just for Taylor. Thus, request number 1 fails to satisfy the second and third prongs of the Shelton test. The request also fails under the Freedman test as the relevant facts and circumstances, such as the need for the documents, LFTC's role as counsel to the Wayfarer parties, the relation or relevance of the sought after information, and the risk of encountering privilege and work product issues, and the extent of discovery already conducted, all dictate that the subpoena may be quashed or substantially modified. Finally, even part from the principles governing discovery from opposing counsel, Rule 45 permits a court to quash an overbroad subpoena. Makes sense. Quashing subpoena where the document request was overbroad in a patent attempt at a forbidden fishing expedition. That's all they've done. I wonder if Blake actually fishes. Fishes? Does she go fishing? Because she's really great at it in lawsuits. The most cursory review of request number 1, including its complex definition incorporated into request number 1, provides ample grounds to quash. At the conference of counsel regarding the dispute, LFTC proposed Lively withdraw its subpoena. And then there's a little footnote here. During a June 2nd, 2025 meet and confer, Lively's counsel expressed the view that Shelton and Freeman do not apply because 1, LFTC is acting as a participant in the actions and thus should be treated as any witness, not a lawyer. What? Blake How about Gottlieb then? How about Gottlieb? Fish after new jobs. That is so good. That is so good. So they're saying you're not a lawyer, you're a participant in the action, so you should be a witness. Two, this is what they're dealing with behind the scenes. I can't even imagine. This is why I can't be a lawyer. There's no way I'd be professional in that situation. Two, Bryan Freedman, the LFTC partner who is lead counsel in this matter, communicate with defendants. Of course he did. The defendants are his clients. Such communications are privileged. That's so so that Shelton and Freeman do not apply because Bryan communicated with the defendants. Oh. Can you imagine dealing with someone like this? I can't imagine being Bryan Freedman in that situation and with a straight ass face, Gottlieb is looking at me and saying, that doesn't apply here because you were talking to the defendants. You mean my clients? How am I supposed to help them if I don't talk to them? These people are nuts. Oh my God. I just can't. Lively's contentions. At the outset, as Linear acknowledges, this district is mixed on what shared standard applies when a party attempts to depose opposing counsel, with some courts applying Freeman and other applying the more stringent Shelton assessment. As between these frameworks, in the absence of Ninth Circuit or consistent district authority, the court should conduct its assessment pursuant to the Second Circuit's Freeman analysis, which more closely aligns with the purpose of discovery and is the standard that would be applied by the issuing court. All right, let's have a look here. Another footnote. While Freeman and Sheldon related to attorney depositions, Miss Lively has intentionally pursued a less intrusive device by serving only written discovery at this point. Thus, the court may wish to evaluate whether discovery is warranted under Federal Rule of Civil Procedure 26 in lieu of the more intensive analysis under Freeman and Shelton that is applicable to attorney depositions. Example in Re Allergan, 2016, applying Rule 26 analysis stating, it is not at all clear that Shelton extends to other forms of discovery besides attorney depositions, and other courts applying Shelton have actually encouraged the use of written discovery as a viable alternative to deposing opposing counsel. All right. So there's talking about Shelton. The Shelton approach with the spirit of the rules 1 and 26 of the Federal Rules of Civil Procedure, applying Freeman in absence of controlling guidance. However, whether under Freeman or Shelton, Miss Lively's discovery as to this information is warranted. First, request number 1 seeks a narrow set of documents that are highly relevant. So this is Blake Lively's contention. Request number 1 seeks a narrow set of documents that are highly relevant and indeed crucial to the Lively action. Specifically, it seeks the production of agreements between Linear and any content creator. She just won't drop it. She's obsessed concerning certain topics related to the Lively action, whether or not such agreements exist, and with whom is relevant to how the Wayfarer parties pursued the alleged retaliation campaign since August 2024 through today. Indeed, it would be highly relevant to Miss Lively's claims if, for example, the Wayfarer parties have access to and are able to direct negative messaging through certain content creators' platforms via Linear. I have never been contacted by any of them or paid in any way. I keep joking that with a farm animal sanctuary, I wish I had access to billionaire money, but I don't. This possibility is not merely hypothetical. Mr. Freeman's Rolodex of clients has included several influential figures who have been notably vocal regarding the Lively action. Miss Lively is entitled to know whether any content creators currently have any agreements to create or influence content or otherwise alter the public narrative in regards to her. So I'm guessing she's talking about Megyn Kelly, who I find Megyn Kelly would say what she wants. Yes, thank you so much. I always write, like the stream, hang out with us, stick around. We go live pretty much daily around 10 to 11 a.m. Eastern. But if you enjoy media manipulation and how Blake's manipulating the media, check out the media manipulation playlist. There's a lot of good, great content there and deep dives. So I'm guessing she's talking about Megyn Kelly. I can't, like, Megyn Kelly just comes across as the person as I don't know. I just don't see her as being someone that if she disagreed, that she would still toe the line in terms of like giving a slanted interview with Bryan Freedman. I think she genuinely, when she says that she believes in him, she believes Justin, she puts her claims forward. I think those are legitimately hers. And he's probably speaking about Perez Hilton as well, I imagine, because Perez has talked about how Bryan Freedman's his lawyer. But those are two people. Where's this Rolodex, Blake? I don't doubt he has other high-profile clients, but those are the two big-name content creators I can think of that they're alluding to. Miss Live is entitled to know whether any content creator currently have any agreements to create or influence content or otherwise alter the public narrative regarding her. Lanier does not claim that this information is relevant to the Lively action, instead argues only that the information is not crucial to Miss Lively's SH and emotional distress claims. I thought she dropped the emotional distress claims. In other words, by Lanier's own concession, this information is relevant to at least Miss Lively's other claims, including her retaliation and conspiracy claims. This is precisely Miss Lively's point. This information is crucial to Miss Lively's ability to document the untraced. Oh, yeah, there's their names. I should have just kept reading. The untraceable retaliation campaign against her by enabling her to propound discovery into the Wayfarer Party's digital and media networks, which Lanier may have taken steps to conceal. So it says here, Mr. Freedman was Perez Hilton's there. Yeah, I figured that's who they were talking about. Attorney. Megyn Kelly is negotiating her exit from NBC, and he was her lawyer there. Megyn's been very honest about that. Second, there's substantial need to obtain this information from Lanier, as no other means exist to obtain the information. In particular, to the extent such agreements exist, they'll be exclusively in the custody, possession, and control of Lanier and a universe of content creators that cannot be identified, let alone comprehensively, except through Lanier. Lanier does not dispute this consideration. Third, Lanier's involvement in connection with this information is not in its role as litigation counsel in the pending litigation. Rather, given that Miss Lively filed the CRD complaint on December 20th, 2024, the work that Lanier provided until that date was exclusively as a witness to the underlying events. I feel like if someone's hired by a lawyer, like if they're your lawyer, even if it's before a CRD complaint, they're still your lawyer. It's weird. Likewise, any work that Lanier performed in deploying or directly retaining content creators to further a retaliatory anti-lively narrative since that time would not be a furtherance of litigation strategy, but instead as an agent involved in the liable conduct. Discovery is warranted in these circumstances. Fourth, such information is not privileged or otherwise protected work product. While Lanier argues that request number 1 targets privileged information in the event that content creators were retained to advance the goals of the litigation, which would be indicative of the retaliation campaign of Miss Lively, alleges counsel agreements or engagements are not privileged. While this alone resolves the issue, given Lanier's invocation of primarily New York authority, it bears clarifying that Lanier's non-traditional role in this case, extending far beyond that of litigation counsel, would not encompass the content creators in any asserted privilege. Oh, shit. I didn't mean to do that. Oh, no, you guys are still seeing the same thing. I'm like, damn it, I didn't mean to click on anything. I didn't realize there were hyperlinks. Mr. Freedman appears to have built his brand on blurring the lines between acting in his capacity as an attorney and serving a public relations function. I don't think that's the case at all. Public relations teams and the lawyers work hand in hand. Like, for example, Tree Payne is going to work hand in hand with Taylor's lawyers because it all matters and it's all part of the like it's all intertwined. But also, you want to talk about a lawyer acting, Blake, let's talk about, she's so delusional. So delusional. You want to talk about a lawyer acting as a PR agent? Wasn't Gottlieb making, like, again, am I going crazy? Maybe I've been sick from trying to understand Blake. I don't know. Maybe it makes you ill. Maybe I'm just crazy for even trying. Gottlieb was making the rounds. He went on CNN. He went on TMZ. He has been making the rounds. You could argue as her PR person. Because I don't see a PR person making the rounds for Blake. So Blake, is Gottlieb your public relations person? Because what's good for the goose is good for the gander, as the saying goes. Bryan Freedman should sue Michael Gottlieb for being the real fact witness. And isn't he the one that apparently was, now correct me if I'm wrong, but isn't he the one that was part of the extortion issues with Taylor? It does. They make you feel like you're going nuts. Yes. Perfect. Thank you. I thought so. Not just a witness, but the author of extortion threats against Blake Lively's, against, was that Taylor Swift's lawyers? So, Blakey, we need to talk because you lost the plot. And Gottlieb is also the one that dragged Taylor's name back into the headlines and allowed CNN to clip the interview and use Taylor as one of the shorts. Gaslighting through legal filings. Literally. I'm not going nuts. I know it's true. While Freeman feeds his... Okay, Ashley, just deep breaths. Well, Freeman feeds his favored press outlets. Just going to breathe on filings and colorful statements. Confident that friendly voices on social platforms will amplify his message. Those who run counter to his interests know they'll face his ear. Everyone has a favorite. For the love of God. Blake has been running to people this entire time. Blake runs to people. When Taylor Swift's subpoena was dropped, Taylor's team didn't run to people. Justin's team didn't run to the media. Blake Lively's team had a freaking statement ready to go and something that had nothing to do with her. Blake ran to the media. Blake constantly has exclusives and people to the point that everyone that's not even in PR is starting to catch on that Blake's favorite place is people. You also want to talk about favored press outlets. The New York Times. Let's also talk more about favored news outlets, Blake, because your CIA guy, Nick Shapiro, was the one that connected with his favorite journalists. And for anyone new to the channel, like, subscribe, hang out, check out the videos on Nick Shapiro. I have a lot on Nick Shapiro. In fact, I have so much exposing Nick Shapiro that every time publications do hit pieces on Justin Baldoni, they quote me in regards to Nick Shapiro. Because they want to discredit anyone that says anything about Nick Shapiro. But you want to talk about favored news outlets? Nick Shapiro is the one who was contacted as part of like the cover up of the Hunter Biden laptop. He was enlisted as part of the agents to connect with his favorite news outlets to get the story they wanted published with the headline and the words they wanted. Nick Shapiro was the one that did that. Nick Shapiro's the one that got that story about Hunter Biden. This isn't a political talk. It's just the truth out where he wanted. So their story could be pushed. Blake, ask Nick Shapiro about his time at Airbnb, where stories wouldn't even make the news because he was paying people off. Stories where people, like real situations, were SH'd at Airbnb properties, where they were cleaning up body parts, holes in walls from guns. That's your PR guy, Blake. Don't come with this bullshit about favored news outlets, because y'all have them. Every single celebrity has a favored news place to go with their exclusives. Big deal. Freedman has one too. Shock Pikachu. This is ridiculous. If she hadn't hired the sleaziest of the sleazy PR, Nick Shapiro, and for anyone that is new to the channel, again, check out my exposés on Nick Shapiro with Airbnb. If she wasn't the one running to the press every chance she got, I might be like, yeah, okay, I see it. But you hired Bottom Barrel, the guy, you're a voice for women, Blake, but Nick Shapiro was paying off women that have been SA'd, SH'd, families, paying off families where their kids had lost their lives at Airbnb. You want to talk about sleazy, scummy PR? You want to talk about sleazy, scummy people to hire and bring on your team? Okay. And I know every time I talk about Nick Shapiro, my channel gets hit. So I know that no one wants information about him getting out. And every time I talk about him, I end up in a hit piece and your bullshit hit pieces against Justin Baldoni. So I know y'all have a problem with the real truth about Nick Shapiro getting out. Doesn't really fit the fighting for all women BS narrative that Blake's been putting out. Fighting for all women. How about all the women that Nick Shapiro paid off? Give me a break. I don't even know where I am anymore in this. So lost. All right. That non-legal spokesman role extends to this case where I can barely read this, where Bryan Freedman has prioritized public relations to point that his inflammatory filings apparently made to create a press uproar were recently struck from the record by the issuing court. So she's also using that against them. And then she brings in Justin Baldoni's lawyer wants to sell tickets to Blake Lively's deposition for this reason, exclusive. Okay, that was funny. That was funny, though. Maybe she's just salty because he went to People, and that's her place. But she also copied Taylor because that was Taylor's first. I feel like I'm in high school. This is ridiculous. So she's quoting Bryan, since Miss Lively is open to testifying, let's make it count. Baldoni's attorney, Bryan Freedman, tells People, hold the deposition at MSG, sell tickets or stream it, and donate every dollar to organizations helping victims of DV. In this scenario, attorney, client, and common interest protections could not encompass the content creators as public relations professionals retained by Linear because they would lack any legal purpose and would not facilitate Linear's legal representation of its clients in the Lively action. I just want to write this page down. Just give me 1 second. So I want to come back to this. Because you all know I'm going for Nick Shapiro again with this. Yeah, I'm doing it. I don't care. I'll do it. I'll do it, Blake. Was it Justin's team? Don't threaten me with a good time. I'll do it. All right. So Linear's involvement and connection with this is not his role as litigator, not privileged or otherwise protected by work product. We have a long way to go. We're going to have to rush through some of this. Loss alone resolves the issue. The invocation of authority, it bears clarifying that Linear's non-traditional role in this case, extending far beyond that of litigation counsel, would not encompass the content creators of asserted privilege. So they're basically saying content creators aren't part of privileged information. But I can see what he's saying where he's like, that's not, he says, I'm not saying that we've done that, but even if it's still all connected. It's still part of strategy. In this scenario, attorney, client, and common interest protections could not encompass the content creators as public relations professionals retained by Linear because they would lack any legal purpose and would not facilitate Linear's legal representation of its clients in the Lively action. That's actually an interesting line. Content creators as public relations professionals retained by Linear. I'm just thinking, is there a day where, because this is what I don't do PR. I have no interest. There's no way. my life is being consumed by PR, and I definitely wouldn't do crisis PR. But it's just interesting. I wouldn't talk about a case I was involved in, but it's just interesting to look at it as, do they represent some, could, in theory, a content creator? I actually like that line of thought and that intellectual question and legal question as well. Could a content creator be seen as a public relations professional? The law might have to catch up to something like that. That's actually a cool thought point that I want to even think about myself. That's interesting. The subpoena also is not overbroad and unduly burdensome under Rule 45, including for the reasons stated above. Linear bases this generic objection on the length of definitions and instructions, which are criticized as somehow simultaneously complex, yet also open to interpretation. Well, yes, something can be complex and also open to interpretation, Gottlieb. While Linear specifically calls out the detailed definitions of content creators and digital campaign as problematic, it fails to explain how those definitions are ambiguous. Nor does Linear or its out-of-circuit cases otherwise address any other complexities introduced by request number 1 that would demonstrate it poses an undue burden. Request for production number 2. For the time period July 1st, 2024 through present, all documents concerning or relating to any invoices, including invoice entries for services rendered or third-party services or similar descriptions involving, between or involving you, including on behalf of the Wayfarer defendants and any content creators where such invoice is concerning or related to the consolidated action. Ms. Lively, Mr. Reynolds, any of the Wayfarer defendants, and the digital campaign or the film. For the sake of clarity, this request includes invoices in which you are involved at any point in any payment chain to any content creator. Oh my God, they just won't drop the content creator thing. Whether directly or indirectly, including but not limited to where another person or entity is the final payer. LFTC's contentions. Request number 2 seeks invoices to LFTs from content creators under either Shelton or Freeman. Request number 2 should be quashed on the same grounds as request number 1 because it imposes an excessive and undue burden on litigation counsel, including an effort to invade the attorney-client and work privileges to open the door to discovery of their litigation strategy. First, the request is extremely overbroad and requires the application of sweeping and ambiguous definitions. You is defined to include Linear, Freeman, Tauman, and Cooley, LLP, any of its officers, directors, employees, partners, members, corporate parents, subsidiaries, affiliates, successors, assigns, or any related entity. Discovery requests should be properly particularized, and LFTC should not be required to guess at what is being sought and from whom, i.e. LFTC's officers, directors, employees, partners, members, corporate parent, subsidiaries. Holy crap. Similarly, content creator is vague, defined as any individual or entity who seeds, generates, creates, or influences social media content or provides digital services. Provides related digital services. Is that me? I do provide related digital services. I kid. A description which is, to say the least, open to interpretation. In fact, these sweeping definitions embrace, among other things, damn it, did my mouse just die? My mouse just died. Hold, please. I have got to plug in my mouse because I never have a fully charged mouse. Now I'm not going to be able to find the charger either. Okay, and for a design on a mouse, Apple, what is this shit? Anyway. What do you guys think? Oh, I can't even scroll comments without a mouse. Damn it. I'll come back to comments in a moment. Okay. Coming down here. So they're looking for associates, subcontractors to communicate information regarding Blake Lively, Ryan Reynolds, Ryan's companies, Blake Lively's companies, their families. I don't think anyone said anything bad about their families. The Wayfarer defendants, the film, or the consolidated action on any social media, news outlet, or other internet platform, and or to seed, influence, manipulate, boost, amplify, or engage with social media algorithms, narrative, or virality, as well as the use of bots or inauthentic accounts, as described in the Lively complaint. It also assumes a digital campaign exists or existed. Second, invoices to LFTC and the broadly defined content creators are not crucial to Lively's claims of SH and emotional distress. Third, request number 2 seeks invoices from content creators through the present. The common interest joint defense doctrine explains application of the attorney-client privilege and work product doctrine to communications with third parties in pursuit of a joint strategy in accordance with some form of agreement, whether written or unwritten. So scroll down a bit. This principle applies to public relations consultants who assist in the rendition of legal services. Communications among target, her lawyers, and public relations firm for the purpose of giving or receiving legal advice were protected by attorney-client privilege. And copper market antitrust litigation, confidential communications between public relations firm and corporations counsel that were made for the purpose of rendering legal advice or protected by attorney-client privilege. Yeah, I'm so interested in how the law is going to evolve. Like, this is just kind of a thought process I have that I can't drop now, because in theory, could you hire content creators as part of your social media team, as part of your marketing team, as part of your PR team? I don't know. Like, to me, I don't see why not. If she can have mainstream media allegedly paid by Ryan Reynolds, Justin Baldoni content creators not paid, what's the big deal here? Yeah. And they're definitely using their contacts 100%. Finally, but that's it. Yeah, it's just such an interesting kind of thought process that now I can't let go, because that's interesting. And I think the law is going to have to also eventually catch up to that potentially, because I don't see the problem if you hire content creators to be a part of your team. I don't see a problem with that. I would imagine you have to disclose it, but I don't see I don't know. Would you? Would you not? I'm not sure. I know you have to disclose if it's a sponsored ad. I don't know if you'd have to disclose it, because I don't know if the law's caught up to it, honestly. Finally, even apart from the principles governing discovery from opposing counsel, Rule 45 permits a court to quash any overbroad subpoena. Lively's contention. Oh my gosh, she just doesn't stop. Like request number 1, request number 2 seeks discovery regarding digital and media network that includes unknown content creators deployed in connection with a retaliatory, untraceable campaign against Ms. Lively. Whether and the extent to which payments were made for services rendered. We're not reading every single line. She just keeps repeating herself. So they're looking for invoices. So they're saying, as to burden, while Linear mostly bases this objection on the definitional criticism addressed above, it additionally complains that the definition of you is overbroad. But the request clearly seeks information as to Linear's payment accounts, and in any event, that definition must be understood by Linear, since it is narrower than the definition of you that Linear regularly adopts in the underlying action. Request for production number 3. For the time period of July 1st, 2024 through present, all documents concerning or relating to the payment between or involving you, including on behalf of any Wayfarer defendant, content creator, where such payment is concerning or relating to the consolidated action, Miss Lively, Mr. Reynolds, and any of the Wayfarer defendants, the digital campaign, or the film. I like Blake can't accept that people didn't like her. For the sake of clarity, this request includes payment in which you are involved in any point in the payment. LFTC's contention, so Justin's law firm's contentions. Request number 3 seeks documents, evidence, payments by LFTC to content creators. Under either Sheldon or Freeman, request number 3 should be quashed on the same grounds as request number 1 and 2, as it imposes an excessive and undue burden on litigation counsel and open the door to discovery of LFTC's litigation strategy. I agree. I'm just more interested than anything over the fact of, like, why not hire content creators? And is there anything that legally obligates you to disclose that if you are part of a team, social media team? I don't know. People may say, ethically you should, and there could be an argument for that, but I don't know if legally you would have to. I genuinely don't know. So again, they're just saying overbroad. It's the same thing. It's vague. Content creators is vague. They say any individual or entity who seeds, generates, creates, or influences social media. They say, in fact, these sweeping definitions embrace, among other things, any person who posts on the internet. So same thing they've been saying. And vendors such as digital service vendors hired to provide litigation support. See, that's what I'm saying. In fact, request number 3 seeks payments from LFTC to content creators through the present. A request for documents from opposing counsel during the litigation potentially implicates multiple privileges, including the attorney-client privilege, attorney work product protection, and the litigation privilege. The definition of digital campaign. Like, the thing is Blake will take anything here. Oh, I agree with you. Blake's definitely using content creators. Blake will take anything, because if there's even like a shred of anything, of Bryan texting Megyn Kelly and asking if she wanted to do a live or something, she's going to twist it into this wild PR campaign of like, see, they were all working against me. Like, anything, the most innocent little thing, she'll twist. So they keep going on. Digital campaign, equally obtuse and broad. It's the same things. They're fighting on each one. Payments by LLC to the broadly defined content creators are not crucial to Lively's claims of SH and emotional distress. And that's what I'm saying. How is that relevant to what happened on set? I want Bryan Freedman to be like, girl, have you forgot what this all started with? Have you forgot? Third, request number 3 seeks payments to content creators through the present. A request for documents from opposing counsel during the litigation potentially implicates multiple privileges, including attorney-client privilege, attorney, same thing, work product protection, and litigation privilege. So they're saying this principle, the Sheldon and Freeman, it all applies to the public relations consultants who assist in the rendition of legal services. So they're saying, again, request number 3 fails to satisfy the second and third prongs of the Sheldon test. The request also fails under the Freeman test as the relevant facts and circumstances, such as the need for the documents, LFTC's role as counsel to the Wayfarer parties, the relation or relevance of the sought after information to the pending litigation, the risk of encountering privilege and work product issues. And apart from all that, 45 says that they can quash from an overt broad subpoena. Oh my gosh, she's still going with her contentions. Materials in conjunction with payments that would reveal a covert network of content creators. This sounds like, I don't know. This is wild. Paid by or involving Lanier, including on behalf of the Wayfarer parties in connection with the retaliation campaign. As with request number 2, the payment information sought in request number 3 is crucial to understanding the nature of the relationship among the Wayfarer parties, Lanier, and the unspecified content creators who collectively may have been harnessed to influence the public narrative against Miss Lively, both before and after the Lively action. Such information is manifestly relevant to Miss Lively's claims. Request for production number 4. Now she's going to say, like, no, even the mean messages people are leaving about me being too old to be in It Ends With Us, that was all this smear campaign that Justin created against me. I just don't understand why it would work for him to have a smear campaign against arguably the biggest actress in the movie, sorry. Like, if he destroys her before she launched her CRD complaint, what does he get from that? What does he get for that? Hi, Julia. What are you up to, baby? I just don't understand the logic on why he would want to sabotage Blake. Request for production number 4 for the time period of July 1st, 2024 through present. Documents sufficient to identify the names of the financial institutions. They even want the financial institutions, the names of the account holders, and any account numbers associated with all bank accounts you used to make or receive any payment. Holy moly. LFTC's contentions. Incredibly, request number 4 seeks documents identifying LFTC's financial accounts. Yeah, okay, yeah. Incredibly. No kidding. That's wild. They're like, we want your bank account number, okay? So he says, are you hiding? You're a good girl, Julia. She's a good girl. So request number 4 seeks documents identifying LFTC's financial accounts, including those used to make or receive payments concerning the use of, oh, Jesus, a typo. Digital online content creator or influencer services. Under either Shelton or Freedman, request number 4 should be quashed on the same grounds as request number 1 through 3, as it imposes an excessive and undue burden on litigation counsel, including an effort to invade the attorney-client and work product privileges to open the door to litigation strategy. First, it's extremely broad. Yes, sweeping definition of you expands on the request for banking information, and not just from the lawyers, but it's officers, directors, employees, partners, members, corporate, parent, and subsidiaries, and requires the application of other sweeping, ambiguous definitions. What? That is wild to me. Similarly, content creator is vaguely defined as any individual or entity who seeds, generates, so they're going the same thing. In fact, request number 3 seeks payment from LFTC to content creators through the present. A request for documentation from opposing counsel during the litigation potentially implicate multiple privileges. The definition of digital campaign, obtuse and broad. Same argument. Second, LFTC's financial business accounts are not crucial to Lively's claims of SH and emotional distress. No kidding. Third, LFTC's accounts receive payments from all LFTC clients, hold trust funds, and pay firm and employee expenses such as health insurance and compensation. That is obnoxious to request that. That is, I don't even know how you make that request with a straight ass face. Request number 4 would require LFTC to identify accounts, including law firm, trust, and operating accounts, which receive payments from its own clients. Lively's only conceivable goal in requesting this financial or this information is improper: to facilitate subpoenas to LFTC's financial institutions. Can you imagine? Yeah, because why else would you need to know the banking name? Why would you need to know where people bank? And that's exactly what it is, just like with the mobile companies. First, it was Blake's dad that gave her fame. Then it was Ryan that gave her more fame. Then Justin Baldoni gave Blake more fame. Blake is a fame leech and couldn't get any on her own. Yeah, pretty much. I've never heard about Blake Lively so much until this. Never in my life. There is no imaginable justification for a party to subpoena opposing counsel's accounts. Hence, the identity of the accounts is irrelevant and certainly not crucial to Lively's claims. It's hard to conjure up a more burdensome or intrusive request. Yeah, no kidding. Thus, request 4 fails to satisfy the second and third prongs of the Sheldon test. The request also fails under the Freedman test, as the relevant facts and circumstances, such as the need for documents sought by the LFTC subpoena, LFTC's role as counsel to Wayfarer Parties, relation and relationships or relevance of the sought after information to the pending litigation, and the risk of encountering privileged and work product issues and extent of discovery. Already conducted all dictate that number 4 be quashed. No kidding. Or substantially modified. I won't even put that in. I am not a lawyer, but I won't even put that in. Like, get rid of this. Finally, even apart from the principles governing discovery from opposing counsel, Rule 45 permits a court to quash an overbroad subpoena. The most cursory review of number 4, including its complex definitions incorporated into request number 4, provides ample grounds to quash. Oh my gosh, she's still going. Request number 4 satisfy Freedman and Sheldon for the same reasons discussed in request number 1 through 3. Request number 4 seeks highly relevant payment information from Lanier in the form of financial accounts that may not otherwise be captured in request 2 or 3. No shit. Like, you don't. The audacity, and which are essential to confirm to whom and when payments have been made. The request is narrowly cabined to accounts that Lanier used for payments for the type of public campaign, digital online content creator, or influencer, alleged to have been waged by the Wayfarer parties in this case. Well, I've been talking to people recently and saying, like, the longer this goes on, it's bad for everyone. But I don't think Blake realizes because she says, this campaign against me that's still ongoing. Because you keep bringing shit like this and makes people like you less. It's all a distraction. All these filings are distractions. I'm starting to think the exact same thing because the docket is just like blowing up every day. Barely knew who she was before, just Ryan's wife. Exactly. Wow. Lanier's only unique argument for request number 4 is that its accounts receive payments from all LFTC clients, hold trust funds, and pay. Their only problem, their only unique argument is that like the account receives payments from everyone. It has information about trust funds and pay employees through it, health insurance and compensation. No big deal. Like, God, they're so dramatic. My God. And that therefore request number 4 could only have been brought for an improper purpose, but this is a red herring argument. I know a lot of red herrings, Blake. I see a lot of red herrings, and I don't think that argument's one of them. As employee health expenses such as health insurance and compensation are not responsive to the request. Besides the unsurprising fact that Linear uses its financial accounts for multiple financial purposes other than the Lively action would not make these accounts irrelevant if they were also in connection with the services the request seeks relating to Miss Lively and others. Of course, the account information itself would not disclose any client confidence, contrary to Linear. Blake, you're the one that also leaked Jed Wallace's health issues, so I wouldn't trust you with anything. I wouldn't trust you with a goldfish if I was going out of town, let alone with my banking information. Request for production number 5. For the time period July 1st, 2024 through present, all documents and communication involving you, content creators, influencers, concerning Blake, Ryan, Wayfarer defendants, digital campaign, the film, the extent responsive documents and or communications are in the possession, custody, or control of Wayfarer defendants. LFTC's contentions. Request number 5 targets LFTC communications through the present involving LFTC and concerning digital online content creator or influencer services concerning Miss Lively, Mr. Reynolds, any of the Wayfarer defendants in digital campaign or the film. Request number 5, which incorporates Lively's sweeping definitions of LFTC, content creator, and digital campaign, should be quashed. Same argument, so we won't read every single one. More contentions from Blake. Jesus. So request number 5. So this is Lively's contention again. The request sought, or the information sought in request number 5 is highly relevant and crucial in Miss Lively's retaliation claims for the reasons that such services have been explained. There can be no doubt that Linear's participation, if any, in communicating regarding content creator and similar services concerning Miss Lively, Mr. Reynolds, any of the Wayfarer defendants in digital campaign or the film is highly relevant to the Lively action. In addition to the verbatim objections raised in the connection with other requests, Linear's objection with request of 5 rests on privilege grounds. It's internal communication. All right. So Blake saying, no, it is not internal communication. So we are requesting all of the documents between you, any journalist, reporter, producer, editor, or any other representative of a newspaper, online news source, podcast, television network, radio station, or any form of media concerning or related to the consolidated action, Miss Lively, Mr. Reynolds, and any of the Wayfarer defendants, the digital campaign or the film from July 1st through 2024 through present. LFTC's contention. Request number 6 seeks communication between LFTC and the persons broadly swept into the definition. And a myriad of unidentified journalists, reporters, producers, editors, representatives, and newspaper, online news sources, podcasts, television networks, radio stations, or other forms of media. Basically everyone. Have you ever, Bryan Freedman, have you ever spoken to anyone, are radio stations even a thing anymore? I don't know. Have you ever spoken to anyone about this case? Have you spoken to the neighbor's golden retriever about this case? We are going to have to subpoena the golden retriever to see what he's spreading to his network about Blake. Wild. So it says here, the sweeping request also trespasses on the rules disfavoring discovery from opposing counsel. it's, basically the same arguments. In light of the First Amendment's guarantee of free speech, a smear campaign is not in itself actionable. Oh, let's go back up. The sweeping request also trespasses on the rules disfavoring discovery from opposing counsel. LFTC's communications with the media are relevant to the key issues, whether Lively was SH'd on the set of the film and whether either side defamed the other. In light of the First Amendment's guarantee of free speech, a smear campaign is not in itself actionable. If the claim is defamation, the issue is whether certain statements by LFTC on behalf of the Wayfarer parties were false and malicious. The mere fact that LFTC may have communicated with media is irrelevant. Further, Lively has other avenues to obtain information relating to the communications with the media. I still think she's trying to get Freedman off the case. I honestly think she's trying to get him off the case. Yeah, that's why I'm like cutting out a lot of this, because it is so exhausting. Subpoena her brother for the bad history. Yep. She keeps going. Number 6, Lively's contentions. Miss Lively's amended complaint expressly alleges that Mr. Freedman defamed her repeatedly while acting on behalf of certain Wayfarer parties. Gottlieb, has been out there as well, Blake. The extent to which Linear has communicated regarding Miss Lively related subjects to a network of reporters planting false or misleading narratives, defamatory assertions, she's saying is relevant. Mr. Freedman is likely to be the only person whose communication will reveal the number and identities of the numerous unknown third parties to whom he disseminated defamatory statements about Blake Lively. She doesn't even know. She's just like, it had to have happened. How do people not like me? Tell me the third parties. And they're like, it didn't happen. And she's like, no, because everyone loves me. People think I am beautiful and they think I have a perfect family. How can they not love me? I'm adorable. And they're like, no, we don't have this, Blake. And she's like, no, I know it's just invisible. So you need to give it to me. And Justin Sai's like, it's invisible because it never happened. And she goes, no. I know it happened because it's impossible that people don't like me. That is literally the and Bryan Freedman's own words. He said that it's invisible because it didn't happen. That is summed up what is happening. So they say Linear's only other argument is a definitional objection where it complains that it should not have to guess. So request for production number 7 for the time period August 1st, 2024 through present, all documents and communications reflecting any communication with any source that provide you information relating to or that form the basis for Mr. Freedman's public statements regarding Miss Lively. LFTC's contentions. So this is Bryan Freedman's contentions. Basically, request 7 seeks documents and communications with any source that provide LFTC with information that form the basis. Surely Lively understands. Surely Lively doesn't. You're giving her way too much credit, buddy. Way too much credit. Surely Lively understands that as lead counsel for the Wayfarer parties, Mr. Freedman learned about the facts from his own clients. No, she can't understand because her and her team are also confused that you talk to your clients. Blake and her team are confused that Bryan Freedman talks to his clients. So no, of course she does not understand that you're getting the facts from your own clients because she's confused that you're talking to your clients. A request for communication between LFTC and any source of information imparted to LFTC partner Bryan Freedman on its face sweeps in attorney-client communications and likely work product. Surely Lively does not seriously believe that such communications are discoverable. Yeah, she does. She does. She 100% thinks it's discoverable. She 100% does. How is that surprising at this point? I would have put, not shockingly, Lively does not seriously believe that such communications are discoverable. But maybe that's too snarky. Moreover, request number 7 implicates communications protected by the common interest privilege. Zoom through some of this. Lively's contention keeps going. I could never be a lawyer. So it says request number 7 relates to Mr. Freeman's sources for multiple, often defamatory statements identified in Miss Lively's complaint. This information is crucial to her retaliation defamation claims and, as conceded, exclusively obtained from Linear. To be clear, the subpoena is not seeking any communications exclusively with the Wayfarer parties and where such information would be within the possession of the Wayfarer parties. Rather, request number 7 seeks information as to any other person who has provided Linear with information to support Mr. Freeman's vehement assertions directly relating to Miss Lively. So it's a quote here. Blake and our legal team have just one heinous pivot left, and that is to double down on the revolting fake SH allegations against Mr. Baldoni. Well, I mean, if his clients had said that they're fake allegations and his clients had said that they were false, wouldn't that go into his assertion of those statements? And then Bryan says, we will not only continue to defend our clients against Blake's power, privilege, and all-out lies, but we will now fight even harder for the voiceless in the DV community who are unfairly suffering while she continues to push her own self-serving and selfish vendetta to the media. I mean, she is. But I don't understand how am I missing something? Let me know in the chat. Am I missing something? Because to me, I just feel like that came from his clients who are like, we did not do this. We didn't do it. It's wild. Linear's invocation of the public relations related privileges in connection with this request make little sense. If public relations consultants are sources for the defamatory assertions made about Blake Lively by the partner of Linear, Miss Lively is entitled to know as such communications would not warrant common interest protection. She is batshit. So Bryan Freedman's contentions. 8 seeks LFTC's phone records up until the present sufficient to show calls with any source that provide information that was the basis for Mr. Freeman's public statements. Burdensome, like it's the same things. Fails to satisfy the Shelton test. Overbroad. She keeps going. Lively's contentions again. Linear makes no explanation as to why privilege would apply. And of course, none would apply to the numeral non-content information request. Oh, that's it. Oh, we made it to the end? The hell is the rest of the 40 pages? Wait, it just ends there? Last, although Linear does not invoke privacy concerns, the reasonable limitations to sources rather than all calls, and the request demonstrates that it is properly narrowed and not overbroad. All right, let's see what else is here then. Oh, it's all the exhibits. I don't think we need to go through all the exhibits. Let's see what's going on though for them. Yeah, we don't need to go through all the exhibits. All right, so that is that. How do you guys feel about that? This is wild. So it's yeah, we're not going through definitions and everything, but I think we've all had enough of Blake's bullshit for one day. Yeah, we don't need to go through all that. All right, well, that's that. I don't even know what to say about that. I don't even know what to say. But we do have good news. I think so too. I think she's trying to get Bryan thrown off the case. I hope she does get fined for this. Wasted the judge's time. I agree. My feelings. Yeah, that's basically my face. Oh, yay, guys. All right. That is wild. But we do have, there was a motion to compel that was denied on the docket. And then this was also that motion denied for Blake Lively. And we have this here as well. So, and this just came out 16 hours ago. Hopefully more news networks pick it up. That would be my hope. That makes a little bit more traction. Blake Lively denied access to view Wayfarer investigation documents and Justin Baldoni legal battle. So she was denied. She wanted, she was throwing her little temper tantrum with the courts, and she wanted to be able to see the investigation. After she herself turned down, I think it's 3 investigations. She turned down 3, but she wants to see what Justin Baldoni's investigation is saying. She's wild. If it's all true, shouldn't she know? Like, if everything she said is true, shouldn't she already know what the investigation's turning up? Yeah, we're all feeling a garden variety of emotions right now. I love that. So good. That's my thought on all this. If everything is true and she has been honest the entire time, she should know exactly what the investigation is turning up, and she wouldn't need, there would be no worry. But that's the thing with her, is like everything right away. She's like, I need to know. I need to know. No, Blake, you don't. And that is what the judge said. So Blake Lively will not be able to access Wayfair's investigation documents in her ongoing legal battle against Justin Baldoni. According to court documents obtained by US Weekly on Monday, June 12th, Judge Lyman denied Lively's motion to view Wayfair's investigation paperwork. The studio, which was co-founded by Baldoni, conducted an in-house investigation into Lively's allegations. Baldoni 41 and Wayfair opposed Lively's motions. The judge ruled that the documents are protected under attorney-client communications or attorney work product. However, Wayfair, didn't mean to do that. Sorry, guys. However, Wayfair and Baldoni are unable to use any of the protected information in their defense. But, I still think it's a win, and I don't believe they had any intention of using it in their defense. Maybe they did, maybe they didn't, but she's still blocked from seeing it. Wayfair was legally obligated to investigate the concerns raised by Blake Lively and others about the onset conduct of Justin Baldoni and Jamie Heath as far back as May 2023. Lively's lawyers Ezra Hudson and Mike when his name's written out, I know who he is. Mike Gottlieb said in a statement to us. Among other claims, Miss Lively sued Wayfair specifically for its failure to conduct such an investigation, an independent cause of action under California law, and the 6th cause of action in her amended complaint. The statement continued, today the court ruled that while Wayfair is not required to produce documents related to the investigation, it only recently launched after it wrongfully sued Miss Lively for $400 million, but that it also can no longer rely on that belated effort as a legal defense because Wayfair failed to initiate any investigation at the time the concerns were raised. It has now effectively argued itself out of any defense to Miss Lively's failure to investigate claims. So they're twisting it as like, we still win. But I don't understand, because when you look back, Sony came out and said that there was no official complaint, that there's no official SH complaint. So how do you investigate something that was not officially done? You know what I mean? Like, I just don't understand how you investigate something when, what are they talking about, the 17-point checklist or whatever? Because it wasn't an official complaint. Seems like they investigated as soon as they realized all this shit. Lively 30, and we already know this. So that was in the news. I wonder what else is going on for Blake. This is Blake's PR right now. Blake Lively, her preferred cold brew is from New Orleans. I thought she doesn't drink coffee. I swear that there's an interview where she says she doesn't drink coffee. Yeah, there's not really a whole hell of a lot happening in Blake Lively news today. Taylor Swift has ditched Blake Lively. So that's trending. Let's see what's going on for Justin. Give me 1 second, guys. You okay? Sorry, guys. I had someone that needed help. This little guy needed help. I know. Are you feeling better? You okay now? Maybe we won't do that again? All right, I'm back. Okay, sorry about that, guys. I'm like, something is wrong. I hear a help me screech coming from the other room. All right, so this is Justin Baldoni. There's not a lot trending right now. I'm actually really surprised. Judge denies Blake Lively's motion. Perez Hilton's trending. Yeah, there's not really much going on. I'm actually surprised there's not much going on. It's like the calm before the storm. The calm before the storm. There's nothing really going on in terms of SEO for either of them. So I wonder if either side's going to leverage this, because I imagine it's not going to be long before the legacy media and everyone catches on to this new document that's gone up. We'll see what happens. I thought it was a hurt bird outside, and then I realized it was Ashley's. Yeah. I saw a comment. I can't scroll. I don't know why. Freaking Mac products. Let me see if I can fix my mouse. My mouse isn't working, so I can't scroll up to see the comments. But someone said if I think they'll appeal. I don't think so. I don't think so, to be honest, because, you know, the thing, unless their hands forced, because say they appeal, I don't know, one, how you get the judge to recuse, but if it's anything like the Karen Reed trial, Karen's team tried to get the judge to recuse herself, and the judge was like, no, I'm good. I'll just stay. And then appealing, I mean, you're looking at years, and that'd be horrible for both of their PR, in my opinion. I think it would be horrible for both their PR. So I think if there's any way to just like keep things moving and keep whatever you can keep moving, I genuinely think that's best. You don't want to drag this out forever. So I cannot foresee them appealing. Yeah, appealing takes too long. That would be my concern. I think she subpoenaed Freeman because she's afraid of her deposition with him. Yeah, I think so for sure. 100%. She has yet to allege a single solitary thing that she can point to. Everything is so vague. How is this even a case even able to get here? Yep, I agree. Feel like her lawsuit provides a roadmap for what she did to Justin. I agree. Oh, this is wild. So anyway, guys, that is the breaking news in regards to the case. Is she was denied access to the investigation, which I think is great and the right decision, obviously. And then Bryan Freedman is fighting a subpoena from her team. But I genuinely think what they're going to try and do is do exactly what Amber's team did to Adam Wallman and get him kicked off. I think that's exactly what they're trying to do. I don't know. I hope it doesn't. I mean, you want your legal team working hand in hand with PR, especially in a crisis PR situation. So it doesn't seem like out of the realms of what would be absolutely normal and how you'd be handling a situation like this. Maybe put this judge on notice and he'll be fair. Hopefully he's fair. I think she's doing this because she has no case and is afraid of Bryan Freedman's deposition. I think so too. And that's a great point because, yeah, I think what she's hoping for is if she gets approved for all of this and say she gets to subpoena him and all of these ridiculous records and everything. And like I said earlier, say there is one piece of information, like he texted Megyn Kelly and was like, hey, do you want to do a podcast episode? I want to get this story out here. I want to have Justin's side heard and release a statement in regards to it. She's going to have it. She's going to run to the media with the smallest things and turn it into one huge retaliatory manipulation attack against her. And she's going to make a mountain out of a molehill and she's just going to use it against him. And so I genuinely do believe she's on this fishing expedition because she doesn't have anything. So she's desperately trying to find something, and any little thing that she finds, she's going to use against them. I agree. I do think it's going to backfire on her. I wonder if she's worried about all those text messages being admissible, and she's trying to find anything to support those text messages from Jen's phone on the smear campaign side. Anyway, that's a good question. Oh, is it? Her birthday's coming up. What she won't accept is she's having a hissy fit about is that she is not entitled to any evidence and tips given to Freeman without a subpoena until the last hour. Well, and that's true too. You're not I think she expects as soon as Freeman and everyone has any kind of information that they're supposed to call Blake up and tell her right away. But I believe they have grounds for appeal when it's all over. Dismissing with prejudice in the pleading stage and during discovery is so suspicious. Yeah, they might do it when it's all over. Maybe. I don't know. I don't know if there's a deadline. I think someone left a comment on one of my videos the other day and said there's a 30-day deadline or something. But maybe not. Maybe they appeal the whole case. I don't know. All right, my friends, that's what I have for you guys today. I am not feeling that great, so I'm going to go take a nap. But before you go, yes, thank you. Please hit like, subscribe to the channel. And if you enjoy seeing more of the media manipulation side of things, make sure to check out that playlist. I have multiple videos up about Nick Shapiro. So when I went on my little rant about Nick Shapiro and his tactics that he uses, what you're going to want to watch are my videos about Nick Shapiro and Airbnb. Because Blake Lively is in one hand saying, I fight for all women, and the other hand employed a man that his entire job was to hide crimes against women. Just saying. All right, my friends, thank you for being here. It was so nice to see you guys. And I mean, if something crazy drops, then maybe we'll go live again. We'll see how I feel. But with that, I will see you guys in the next one. Bye, guys. And thank you so much for joining me.